speaker is Florencia Rimoldi from the University of Buenos Aires, Argentina, and CONICET. Florencia is an epistemologist, focused mainly in social and legal epistemology, and she'll be talking about inquiry through a conversation in legal trials. So thank you, Florencia.
Thank you, everyone. I will first read like a minimum presentation of what I want to do now. But the theoretical background, actually. Wait. But I'm going to read a lot, I must warn you. So the theoretical background of this presentation. I will be talking about the epistemic dimensions of conversations in law. For doing this, the epistemological approach is a branch of epistemology called inquiry epistemology that has as its object of study epistemic agents as inquirers and the range of actions and procedures that are involved in the process of their inquiries. At the same time, I use another theoretical tool, epistemology of conversation. This is rather new in epistemology, like it's a new fashion, which is the study of the epistemic dimensions of conversations. I am currently working on the epistemic norms of what I've called, for the moment, inquiry conversations. Those conversations in which two or more people engage with the purpose of getting some epistemic good. So now I'll start reading like there. So actually I have a disclaimer. You know, no se lee mucho, no? You can read this. Do you can? Oh. This is Wittgenstein doing in a conference he had to give in English. What I'm doing now is, excuse my English, please try to pay attention to the content, not to the grammar. But I'm taking a more modern approach to this disclaimer, which is Sofia Vergara saying, I am much smarter in Spanish. So take that into account. So the plan for today. I showed that if we accept the idea that trials are cooperative epistemic enterprises, and as such, proper inquiries, then the epistemology of conversation should be introduced as a theoretical tool for understanding and assessing some epistemic-oriented procedures within legal trials. As an example, I take the case of cross-examination and show that if we understand it as epistemically oriented conversation, then we can gain some understanding of the epistemic roles of witnesses and lawyers, as well as why some usual tactics within cross-examinations are epistemically wrong. Maybe we know they are wrong from other perspectives, but are they epistemically wrong? That's the question. So first I'm going to set the three starting points from this talk. No? Trials as cooperative epistemic enterprises and inquiry epistemology. Then, inquiry conversations in law, orality and contradiction and at face value. So I'm going to give some preliminary reasons for thinking that this makes sense. Then I'm going to talk about lawyers and witnesses as epistemic agents, and hopefully, if I have time, I'm going to take the case of cross-examination from the perspective of conversation. So, the first part. The first starting point is quite accepted. In this context at least. Legal trials aim at getting the truth, whether it's intrinsic or an instrumental need, and maybe some other epistemic good, such as understanding, maybe. And maybe also, not only getting at truth, but giving and disseminating truth and understanding, something like Louis, for instance, said today. And the only thing I want to say is that my idea is that caring about truth is not all about accuracy. I mean, even if you only care about truth, that doesn't imply that you're only going to look at accuracy. So that's the first. The second, in order to fulfill their epistemic goals, legal trials are designed as cooperative enterprises in which different agents, by means of different procedures and by playing different roles, are intended to work in a cooperative manner with the expectation of fulfilling those epistemic goals. So here are some concepts: cooperative epistemic goals, agents, and procedures. So what is a cooperative goal? I'm taking Murphy on this, and the idea is this one. If we both have a cooperative aim to promote a good, and in this case an epistemic good, we do not see ourselves as engaged in separate solitary enterprises. The other person's relevant behavior affects the attitude of each to his own requirements. Indeed, we can say that if we all have a cooperative aim to promote the good, each of us does not, strictly speaking, aim to promote the good. This is relevant for the case of law. Each sees himself as working with others to promote the good. Thus, the best way to describe the aim of each might be to promote the good together with others. What is an agenda or an epistemic agenda? Something like a network of tasks or programs to be discharged. I'm going to give some examples now. But the idea is that I need to do some things, to get some things in a certain way. This no se ve. Well, so the conclusion of this is that truth and understanding, which is the main cooperative objective of the law as a whole, of the trials. But in order to do their part, different epistemic agents have different epistemic agendas. This is translated in specific procedures who are carried out by different agents with roles assigned. The procedures are the ones that are regulated by law. Those are the specific procedures. So the example of an agent, a cognitive agenda, a procedure, is the fact finder, who is aiming at a justified verdict of guilt innocence. So here the epistemic agent is the fact finder, judge or jury. The epistemic agenda here is the same as the procedure because it's not regulated. But the idea is that by reasoning or deliberation we're going to get what we want. What do we want? Justified verdict. And the relation to the cooperative goal, which is truth, maybe understanding, is that an epistemically justified verdict tends to give us truth. Is this okay? So, from an epistemological perspective, we can ask a lot of questions. What is a justified verdict? What is the structure of a justified verdict? How well does the agents involved perform as epistemic agents? And the like. But there are some other candidates. I mean, don't look at this. Agents. Well, we have police officers. I'm taking now the whole investigation, not only trials. Police officers, prosecutors, lawyers, not layers. Victim, defendant, witness, expert, fact finders. Some possible cognitive agendas. Gathering evidence. So the police officer, gathering evidence, producing best evidence, making a case beyond reasonable doubt. And specific procedures. Police investigation, recollection and testimony, that's a regular regulated procedure. Criminal forensic science, legal argumentation, legal reasoning. Those are the processes. So how can we interpret and assess them epistemically? That's the question. This is where inquiry epistemology, I think, can help us. The inquiry epistemologist is interested in the activity of inquiry, in how we go about extending our knowledge. They ask questions about the mechanics of inquiry. How do we inquire? They ask normative questions about inquiry. What is a responsible inquiry like? And inquirers, what is a responsible inquirer like? But they are also interested in improving inquiry. They want to make it more effective, better at reaching truth, for instance, and more responsible. And Makina defends an interesting approach, which is non-ideal. So the starting points of non-ideal inquiry, epistemology, are real processes and real agents. So it needs empirical research, but also it takes into account theoretical epistemological reflection in order to assess epistemic agents and the like. So the idea is that legal trials are non-scientific inquiries. So inquiry epistemology can be a way of assessing those specific procedures. Okay, so that's the answer to the question. And I have a perfect example of this by Carmen Vázquez. So she does this. She tries to give some suggestions of design modifications for the case of expert testimony. So look at what she says. The objective of this work then is to go deeper into those tools and that a good procedural design in the legislation should contain, since they would allow a genuine evolution towards the understanding of expert evidence by judges. This is an epistemic goal. This procedure, at least Carmen Vázquez says, is epistemic. Is that the judge understands the proof, the expert evidence properly. So she can assess all the evidence correctly. And she takes as inputs empirical research and theoretical insights from epistemology of testimony. That's exactly an example of inquiry epistemology. So, I think, I don't know, maybe I'll skip this because I'm being a little slow. But this is a problem, but more reasons. So, epistemology of testimony can be a way of assessing beliefs. So, someone told me that B. Is my belief justified? But from an inquiry perspective, that's not what epistemology of testimony would look like. There are more interactions that we have to take into account if we are looking at testimony. If you're looking at testimony from an inquiry perspective, it assesses how could we as inquirers gain epistemic goods by means of the words of others. It's a different question. Anyway, back to the list of the candidates. You remember the candidate, agendas, agents. In legal trials, many of the specific procedures, such as deliberation, interrogation, cross-examination, argumentation, are not static, like the uptake of a statement. So, okay, I'm gonna assess this. Is this reliable? Not. It's not like that. It's interactional. Even more, those interactions are verbal, and they have the dynamics of conversations. So can we use inquiry epistemology for assessing those conversational procedures and agents involved in them? For answering this question, we have to answer two things. can conversations in general be conceived as inquiries? And the second one is, are conversational procedures in law, such as deliberations, proper inquiries? Those are two different questions. We need to answer this, we have to answer these two questions. So, what are inquiry conversations? First, like a small description of what epistemology of conversation is. This is Waldomiro Silva, who says, unlike testimony, I suggest that a conversation is a situation where people exchange and dispute relevant information regarding a proposition. And this is not just the reception of relevant information through the work of others. Besides this, a conversation can be a form of inquiry, since a person can search for truth or knowledge or some other epistemic realization in the process of conversational exchanges, especially in circumstances such as sincere epistemic disagreement, sincere doubts about the content of the truth of the proposition. So from this point of view, a dialogue, a conversation, the exchange of relevant information could be a means for getting epistemic goods. That's inquiry. And I go further and I say there are certain conversations, not all conversations have epistemic ends. When we chit-chat so that we spend time together, ice-breaking conversations, when we deliberate in order to decide something. Those are not conversations that have epistemic goods, like understanding or truth, as their objective, as their goal. They want, we need to make a decision together. We need to feel comfortable with each other. Those are the basic aims of those conversations. But other conversations are properly epistemic. So the definition would be something like this. An inquiring conversation is a cooperative enterprise in which two or more participants engage in conversation with the common purpose of realizing an epistemic good as an outcome of that conversational engagement. So not all conversations are inquiry conversations. Some examples. Conversational engagement after full disclosure. We find out that we disagree. The first thing we do is we share our evidence, our reasons. Maybe that's the reason why we disagree. That's full disclosure. Like, what's your evidence? What's mine? Oh, we share the same evidence. That's not the reason. We are peers. We are epistemic peers. That's not the asymmetry between us. Is not the difference. It's not the explanation of the disagreement. So after that, after full disclosure, we can engage in conversation so that we can find out why we disagree. For theoretical clarification of someone's ideas, just like we're doing now, for instance. Some therapeutic conversations, so I can understand better something that happened, or I can recall something that was repressed, so I aim at getting the truth of something, and this I'm going to skip it. So I think this is what I'm saying, like at face value, there seems to be a commitment with conversation as a method, as an inquiry. The Public Ministry of Prosecutions of Argentina says, and this is not only in Argentina, of course, contradiction is the method for the discovery of the truth. I'm taking this at face value. I know this means maybe nothing, but through the parties there. So I think in legal trials there are some other inquiry conversations. When the judges deliberate, they try to find out what happened or what's the best justified hypothesis. Direct and cross-examination of witnesses. I know this is contested. Direct and cross-examination of experts, less contested. At this, Carmen Vázquez says this is an epistemic-oriented conversation. Not in those terms, but interrogation of the defendant, in the interrogation of the victim, maybe the whole process as an adversarial conversation. So, I'm saying a lot, I know. I don't know, sorry. Inquiry epistemology applied to conversational procedures in law. How would that look like? What is, like, so, in a sense, we have to do, like, apply the definitions of inquiry epistemology. A research on how they are actually designed and an interpretation of the epistemic goal of the conversation. An interpretation of the expected responsibilities of the agents involved as inquirers. Assessment of the effectiveness of the process. Is it a good process for getting understanding, for getting truth? Is it well designed for fulfilling that end? And we can make some design proposals for improving its effectiveness. And we should take into account empirical research and theoretical input from, in this case, the epistemology of inquiry conversations. What is that? What is the epistemology of inquiry conversations? So that's something I'm working on. So I'm not going to say a lot, but I want to say, like, I'm not going to read this, but the idea is that we need to understand the norms that make epistemically correct a movement in a conversation that has an epistemic end. That's the basic idea. When is challenging adequate? What sorts of challenges are adequate? But the thing is that the only thing I want to point out now is that you have to take into account, so the example that I suggest is that it's not as easy as say, okay, if you, since you're epistemically interested in this conversation, then whatever strikes you as, whatever assertion the other person does, that strikes you as epistemically problematic, then you should challenge it. So I think that's wrong. Because you'd have to take a look to what is the epistemic end of that conversation. So for instance, if the epistemic end of the conversation is that a student understands better his ideas, the professor is not making the correct move by challenging everything that he says. Even if she finds it epistemically problematic. It's not going to be as effective as if she waited or she said, okay, move on. So in order, what I'm trying to point out is that the norms of good inquiry conversations are highly sensitive to the epistemic goal, but also to the epistemic goal, if the epistemic goal is agent-oriented, so maybe we are all trying to understand something, such as the judges when they deliberate, and maybe we both are cooperating so that you understand something. And there's also an important thing if the people who are cooperating are symmetrical or asymmetrical in epistemic authority, social power. There's a lot of considerations to take into account. I'm not talking about this now. So, but I want to say one thing, and I move on to cross-examination and lawyers and witnesses. Whatever we plan to do when we try to approach the norms of inquiry conversations, this is just a process, just as epistemology of testimony has done. First, we need to understand the nature of conversations in general. And then, we have to see their epistemic properties. What are good epistemic conversations? So, I'm going to skip this, but this is the first step. Conversations in general, what are they? And so we can say that these things, that conversations are truth evaluable, that they involve people making decisions, and voluntarily, are things that if they are missing from the interchange, from the interaction, is no longer a conversation. That's what I want to stress now. And then you start doing epistemology of conversation. What are the norms for being effective? So I talked about this already, so I'm going to skip it. But just norms of conversational inquiry are highly context sensitive. That's my thesis. So, where are we standing? Until now, I have shown that maybe in law, conversation is taken to be the best method, specific procedure, for fulfilling some cognitive agendas, like a prima facie shown. I have also shown how could we assess them from inquiry epistemology. How could we? But this will imply that witnesses and lawyers, when engaged in conversations such as interrogation and cross-examination, have epistemic responsibilities as inquirers. And how adequate is this picture? So this is what I want to address now. Of course, we have the argumentative image of lawyers. They have no epistemic pressure in interrogation. They are wild animals in procedural cages. Their goal is to destroy the witness' credibility under certain mild restrictions. No known falsehoods, no suggestion, no violence. Even if the process is epistemically oriented, it is forced to say that they are conversational inquirers, engaged in producing a certain epistemic good. And so the procedural constraints that bind performance of the witness, of the lawyer, are compatible with the agenda of persuasion, which is not an epistemic good. And there is much space for epistemic wronging and wrongdoing. Wronging is that doing making epistemic harms to the witness, and wrongdoing is being epistemically irresponsible, without it being the case that the lawyers, without it being the lawyer's professional responsibility to avoid it. So, eventually it's a consequence of the system as it is designed. There's no responsibility. The lawyer is not his role to be epistemically responsible. That's the idea. And he can harm people epistemically without being responsible in an interesting sense for law. I'm going to skip this but what I was talking about, epistemic wrongdoing, let's take the idea of testimonial injustice, agential testimonial injustice. What Lucky says is that a speaker is the victim of agential testimonial injustice when testimony is extracted in a way that bypasses, exploits, or subverts his epistemic agency. So I'm trying to get testimony from you by trying to avoid that you think reasonably. That's the idea. And testimony is extracted when it has been obtained through an interpersonal interaction that bypasses, exploits, or subverts the testifier's epistemic agency. And manipulation, deception, and coercion are the three central ways in which interpersonal processes can extract testimony from a speaker. Manipulation, deception, and coercion. So, we take the case of the most known tactics of cross-examination in a forthcoming article with our colleague, Pablo Roati, that the standard cross-examination tactics are extractive. Their aim is to obtain testimony from witnesses from manipulation, when the tactic is exploiting their anxiety, generating confusion or surprise, handling their emotions. And coercion, this is more debatable, but there are many suggestions that the lawyer has to make some physical maneuvers that are intended to control the witness. This is what we argue in this article. But what is important for here is that under this, under persuasion, under the argumentative model, in an important sense, the lawyer is just doing her job. I cannot blame her professionally. As long as there are not procedures violated. So, the contrasting image, the contrast image that I want to put forward is that intervention and cross-examination are, I said this already 10 times, but are conversational inquiries, procedures with a cognitive aim, maybe to allow best evidence or that the judge understands expert evidence, as we saw, that are collaborative, and it is through the conversational interaction between lawyer and witness that the cognitive agenda is expected to be fulfilled. It is through conversation. So, spoiler, if we take the epistemic agency of the witness, we don't have a conversation anymore. And so we can make the lawyer responsible as an inquirer. That's what follows from this. Now, this is not incompatible with the role assigned to the lawyer. I mean, she has to be partial. I mean, she has to make the best case. But I believe that there are many ways of accounting of that role, that professional duty, that can be epistemically rational. For instance, take the epistemic obligations to special people with which we are related. Like, there are many people who say that I have epistemic obligations to my beloved ones. So if someone puts me with evidence that they have done wrongly, I have an epistemic duty to be very strict with that evidence, to not believe easily on the basis of that evidence. So I think there are many ways to make sense of the duty of the lawyer and it's her epistemic responsibility. And so think that they are inquiring through conversation. Well, I already said this. And what about witnesses? Well, in the same vein, they are also subjected to epistemic evaluation. They should answer truthfully, that's already stated. But they also have to be dialogically responsible. Not being dialogically responsible is a reason to distract in general, but from the perspective of the right procedure, conversation, if we follow the argument, it might have legal consequences. So with this, I'm finishing. I want to. So Henderson she thinks that a cross-examination has an epistemic aim, to get the best evidence from the witness. And she thinks that there are three principles that govern, that rule, I don't know how to say it in English. So these three principles, factual focus, voluntariness, and facilitation of full inquiry. And I think this is perfectly compatible with the idea of a method of conversation. I'm going to skip this because I don't have time, but I think voluntariness particularly is necessary as a methodological necessity. I don't know, I'm sorry, I'm just, my English. Remember the first disclaimer, please. Please. So, we can see procedural rules as rules for well-ordered conversation as an inquiry. So when it's relevance, leading questions, no compound questions, no argumentative, ask and answered, they're all trying to order a conversation. And if we add what Henderson points out, voluntariness as method related, it's not only about reliability, it's also about following the chosen method for inquiry. And this has to do with what conversations are. If you don't respect your the other person which you're conversating with, if you violate their epistemic agency, you're not conversating anymore. And you're not following the method that is supposed, we can interpret the law wants us to follow. So synthesizing, and this is the end. Interpreting cross-examination as an inquiry conversation explains why testimonial extraction is wrong methodologically, since voluntariness is a basic feature of conversations. When lawyers extract testimony by means of the alleged extractive tactics, they are in fact being epistemically irresponsible inquirers. They are not following the method they are supposed to follow. And this, since I haven't talked so much about Henderson, this is not so relevant. So, thank you.